State versus Kathleen Perry, 16-87, forgery, theft. Good morning.
Morning.
Do you have a lawyer, ma'am?
No, but I've already filled out the application for a public defender.
Okay.
Last Friday, when I got out of jail.
Did you bring it back to our office?
I filled it out in the office.
Okay, are you working, Miss Perry?
No.
She'll probably qualify, so if someone would stand in with her.
Yes, sir. Yeah, we'll waive reading of the information or plea of not guilty.
Very well, we'll enter that plea of not guilty and send out a scheduling order. You stay in contact with the Public Defender's Office, ma'am.
Thank you.
Thank you. 16-86, State versus Nathaniel Campbell. Theft by receiving. He also has 15-309, which was a breaking and entering charge. 16-86. What did I say, 89, 86? Is this for arraignment?
Yes, Your Honor. So on 16-86 is for arraignment, Your Honor.
How does he plead?
Your Honor, he's going to enter a plea of not guilty, but he's indicated he's going to hire private counsel on that case, so he'd like
Okay.
to have attorney status on that.
All
Next
right,
time the court's gonna be here.
reappear before Judge Webb on that case on April 28th. And let me look at 15-309.
Your Honor, on that case, we thought it was going to be for resolution, but in light of the new charge, we're going to probably be filing a motion to continue. I can announce to the court that he has presented a cashier's check that's going to take care of restitution in full in that case, and so that will be resolved by a plea, but we want to make sure the other case is taken care of simultaneously.
We'll leave it that as scheduled then.
Thank you, Judge. If he could be excused.
Yes, thank you. 16-75, State versus Katie McElroy, theft of property.
Your Honor, I believe we've previously been appointed to represent Katie. We don't have a file set up probably yet, do we? On the ball.
Okay, the public defender's been appointed to represent you, ma'am.
Your Honor, based on, I think she's been arraigned already.
She has.
Okay. We'll just ask for a scheduling order, and looks like we've received initial discovery.
You'll receive one.
Thank you, Your Honor.
Ready? State versus Natasha Davis, 16-63, possessing controlled substances and drug paraphernalia.
May I approach, Your Honor?
You may approach. Ms. Davis, I've appointed the Public Defender's Office to represent you. Looks like you've already been arraigned, and we'll send out a scheduling order to your lawyer. Thank you.
Thank you, Your Honor.
15-401, State versus Gary Hart. Breaking or entering, theft of property, criminal mischief, obstructing governmental operations.
Your Honor, I represent Mr. Hart. He appears here today. I know that, I think this was brought to the court's attention last time. One of the conditions of Mr. Hart's bond is that he wear this ankle monitor. It's becoming somewhat cost prohibitive for him to keep this on. I've met with him and his mother in my office. She is willing to, he is on bond as well as the ankle monitor. How much was your bond on top of that?
$1,000.
$1,000?
See, I'm waiting on my attorney. I'm on disability court right now.
Did you use a bondsman, or did y'all put cash up?
Bondsman.
Okay. So, Judge, he is secured by a bondsman to secure his reappearance before the court. He is set for trial. We are moving ahead accordingly. We've met yesterday in this case. I don't think we have an agreement yet, but Mr. Hart does appear today before the court to let you know that he will appear for his court appearances. He has done so. He has not violated the parameters of his ankle monitor. However, that the cost is becoming somewhat difficult for him to make. He's pending a disability claim at this point in time.
Well, why did he bond on it?
I'm sorry?
Why did he get an ankle monitor if he couldn't afford one?
Well, that was what you told me I had to do in order to get out, and I'm in court trying to get my disability. I had a bad car accident. And
Your Honor, that ankle monitor is in place because this gentleman has a very extensive criminal history that dates back decades. He was out of jail, out of prison for about 5 days when these crimes were committed. And he did so while living with his mother, with his sister. He broke into a storage unit almost as a matter of course. And the people of Baxter County need this man to be on an ankle monitor. Because quite frankly, the behavior, if the court reviews this gentleman's criminal history, this is something this man has done for years, and it's all theft.
Judge, I don't know if looking at his history that the court would find any failures to appear before the tribunals that he was supposed to appear before.
Well, Your Honor, then this is an end around to get away from an ankle monitor. This is saying, I'll get an ankle monitor for 2 weeks, and then I'll come back in here, and you'll take it off of me.
I tell you what, I'm gonna leave the bond as it is right now. Should he turn himself in, I'll reconsider it.
Okay.